think uh, there is so we've been talking mostly about rescheduling. The other option that folks push for, or having this conversation is descheduling. I think either one of these, either rescheduling it as Schedule 3 or descheduling it from the CSA altogether, would have could have pretty major impacts on the business in our state and in every other state. Could some of those could be beneficial, some of those could be detrimental. I think the biggest takeaway from it and the most immediate impact from a rescheduling, for example, if it happened, is what Slates mentioned. It removes the restrictions of 280E, and that would happen immediately with the rescheduling. Rescheduling it as a Schedule 3 drug doesn't mean that it's legal. It means that if a product is FDA approved, then it can be sold across state lines, subject to restrictions by the government, just like any other prescription drug, for example. So it doesn't mean that there would automatically be legal interstate cannabis sales. It just means, though, that you would be able to take advantage of the tax benefits and the write-offs that you'd be able to do under 280, because those restrictions apply only to Schedule 1 and 2 drugs. I think most of the folks, and Slates has got some other possibilities that may arise if something like that happened listed here. Most of the folks in this conversation that talk about this regularly seem to think that the two big impacts are A, the removal of the tax restriction, and B, just the implication or the message that this sends from the federal level. It's just another huge step suggesting that the federal government is really becoming less and less interested with major restrictions on cannabis. So
yeah, but and the things under the 280E bullet here are, if it's descheduled, I think some of these things you could almost feel more confident would happen. If it's rescheduled, maybe not as much. I think there's people on both sides that argue that rescheduling would result in the anti-money laundering regulatory risk, which applies to the financial institutions and they're doing business with cannabis businesses, insurance businesses, etc. Does that open up interstate commerce, which we're going to talk a lot about? Certainly would think it would lighten the threat of federal prosecution, which is light already, hence the amendment I mentioned earlier. Does it open the door to bankruptcy relief, expand intellectual property rights, two things that are currently very much restricted because of the Schedule 1 status of marijuana? So there are some things that would certainly happen, like 280E. There are others that would likely happen, and then there are just a lot of questions. Clearly, there's a big difference between descheduling and rescheduling. If it's descheduled, it's taken off the Controlled Substances Act completely as a regulated controlled substance, and presumably, it would then just be up to the states. It doesn't mean that it becomes, every state must have legal marijuana, but the states that already have it, there would be no federal impediments if it's descheduled. It would not be regulated like other controlled substances under the CSA. If it's rescheduled, as Jason said, it would remain a controlled substance and would be available to consumers who meet certain requirements. And some of the current Schedule 3 drugs that a lot of people point out are ketamine, Tylenol, codeine, and anabolic steroids. So as consumers can't just go into a gas station and buy ketamine currently, but they can get a prescription from a physician and go to a pharmacy and buy it. So, I mean, that's just some of the issues that we don't know what's going to happen. Most likely the federal government, if it's rescheduled to Schedule 3, will undergo an administrative process where they develop a set of regulations that sets up how one can qualify and get FDA approval for marijuana through the FDA, and then all the details of how it can be sold, how it can be manufactured, what's required, et cetera, et cetera. So like Jason said, that doesn't make it legal from a federal perspective. It doesn't necessarily mean all of a sudden everything from a federal perspective is legal in Mississippi. It gives an avenue to follow that, but on the flip side, the federal government hasn't been enforcing the CSA or marijuana as a Schedule 1. So what's to think that they would if it's a Schedule 3? The flip side of that argument is,
well, it depends on who you talk to and what you read. Some people think that a rescheduling could be, highly beneficial for state businesses like in Mississippi, or for state cannabis business in Mississippi. Some people think it could be pretty disruptive. And I think the reason behind that train of thought, is that if it's rescheduled as a Schedule 3, then it's got to have FDA approval and come under the guidelines that govern the sale of any other drug that's on that schedule, such as having to be sold by prescription in a pharmacy, in a licensed pharmacy, which is different than a dispensary, for example, here in Mississippi, with a different set of regulations here in Mississippi. And so the two don't piece together very well as is. So if the rescheduling were to occur, I think there would have to be a lot of work done at the DEA and federal level and on the state level to make sure that the plans jive together the way that they should, so that the state programs aren't completely upended and disrupted and subject to a whole new set of regulations that require restructuring our code. For example, some of the restrictions in Mississippi's Pharmacy Act, require for Schedule 3 drugs, they're subject to prescription only, and the prescription is only good for 6 months and can only be refilled, I think, 5 times in that 6 months. And that's, of course, different than how it's laid out for permissible cannabis cards and things like that here right now. So there's just a lot of different parts and pieces that would have to be looked at and pieced together. And I think that would take a lot of work on the federal level and the state level. I think the takeaway for you guys is that, if this rescheduling thing continues to gain traction like it is and happens, then that's something you really shouldn't just sit around and wait for. I think you need to be out in front of this, looking, talking to the state about what their thoughts are if this happens, and how they intend to manipulate the program so that things aren't completely upended. So,
yeah, and there's no precedent for this. I mean, whenever ketamine, I don't know the history of ketamine, for example, but when it became a Schedule 3 and doctors were able to prescribe it for patients, there weren't already ketamine dispensaries all over the United States selling ketamine pursuant to state law. There's just simply no precedent for this. I tend to think that whatever the federal government ends up doing, and the agencies that develop these regulations, they're going to clearly create exceptions and keep, at least on a high level, the existing markets. And I just can't imagine that they would disrupt a multi-billion-dollar industry. But everyone knows who the big players are likely going to be, and that's big pharma. You've seen activity already from their side. You've seen big tobacco. I know they've acquired a Israeli cannabis company. This last bullet point here is the Wine and Spirits Wholesalers of America have released a memorandum talking about, safe and responsible adult use cannabis regulations. So the big players in highly regulated industries are getting into this, and one would think they might know what's going on up in Washington and what's on the horizon. This is a repeat of kind of what we said. I mean, I think it just raises more questions than answers. I think one welcome change for rescheduling could be uniformity. Assuming they don't really alter state programs, there might be some guidance at the federal level in terms of advertising, packaging and labeling, testing, some things like that. that would apply to all states to avoid any questions about that, and for operators in multiple states having to adjust their SOPs for different states. It would potentially increase the R&D costs and clinical trials, FDA approval, and would it open up interstate commerce? That's a big issue. So,
well, and it could do nothing.
And it could do
I
nothing.
mean, it could be that it gets rescheduled to Schedule 3, but there's nobody, no industry, no company wants to invest the time, effort, and significant expense of getting FDA approval for any product, and so business continues as usual under the state law and under individual state plans. So
Yeah, because you said you had a matter recently, or you went through a FDA approval process. How long did that take?
a couple of years, and it was incredibly expensive for the client. So I wasn't involved directly in that process, but we were waiting on that to play out before we moved forward. It took a long time and a lot of money. And there are obviously companies like Pfizer and things like and folks like that have the means and funds to do that. But the question to me is whether they're going to approach an investment that way and put that type of time and money into something when there's already product on the market that doesn't have to go through that process. So there's questions about, I guess the takeaway is there are questions about whether this has really any significant impact at all other than the tax break.
Yeah. So interstate commerce is a phrase that gets thrown around a lot when talking about cannabis rate changes. And clearly what that means is marijuana grown in one state or processed in one state can be sold outside that state. What currently is in place is intrastate commerce. So all the programs currently restrict the selling of cannabis products that are produced in one state to be sold within that state. Now, I'll say that some states out west, like California, Oregon, and Washington, have some laws in place and even agreements with neighboring states that once there is federal legalization, and I haven't studied those laws, but on some level, whether it's rescheduling or descheduling, they will have interstate commerce agreements in place where cannabis grown in Washington can be sold to California, Oregon, vice versa. So, and clearly one impact of that is it would increase competition potentially if interstate commerce is completely open nationwide for state legal cannabis markets. It would increase competition in each state. It could drive prices down, but each state could counteract that by imposing maybe certain import or export tariffs, a certain type of tax on interstate commerce. I assume local states could pass laws that might discourage out-of-state products, such as lowering THC limits, have more stringent testing if that's not a federal requirement. You would think maybe it would, as with alcohol, each state kind of has its own set of rules about how it's distributed within that state. So there may be ways for states to create programs and schemes that still are, quote, protecting that state and that state's businesses, while also you can't shut out of-state businesses either because of the dormant commerce clause. And in a state like Mississippi, where the patient numbers continue to go up, but there appear to be more supply than there is demand, there may be exporting opportunities if interstate commerce is opened up. So these are just, again, more things to consider, more things to think about. Another big thing that happened at the end of 2022 was Biden passing this federal cannabis research law. So for decades, the federal government only allowed research of marijuana to be conducted at the University of Mississippi, hotty toddy. But obviously, I think there were a lot of criticisms of the product grown there, and I think everybody finally recognized that there's a lot of much better product being grown all across the country. We need to research the better product, hence the passage of this law. So it is very significant. It's the first ever piece of independent cannabis reform legislation that's passed through Congress. And what it essentially does is it sets up not only an ability for a researcher to get a license from the DEA to research marijuana, it also allows for manufacturers of marijuana to get a license to produce the product and sell it to researchers. And so I've actually helped one client go through this process and apply for a federal research license. And if you look at all the kind of metrics that they judge an application on, it really positions existing operators in legal states above and beyond, or in a better position than someone that doesn't have experience, because it's all the similar criteria that you are all used to seeing with applications, such as your security requirements, anti-theft and diversion, your experience growing the product, etc. There's only one metric that really might disfavor an existing company, and that's the history of abiding by federal law, which again creates one of those inconsistent positions in federal legislation where you may score a lot higher on a federal research application based on all your experience growing a plant that's been illegal under federal law, but then there's this one factor that might be cut against you. But I think all the recipients of one of these licenses for manufacturing are, at least currently, in states where there are state legal programs. And just like a couple of weeks ago, the DEA came out and wants to increase the aggregate production quotas for Delta-9, THC, and other THC products to support this research. So that, and I think there were significant quota increases. So that's just another sign that the federal government is pushing stronger for research of this product, and which I do think is a key piece of this whole rescheduling analysis, because we talked about clinical trials and FDA approval. The federal government's opening up the door for a lot more research to be done, approved by the federal government. They'll have more data, and perhaps the companies that are doing that in accordance with a federal license might be better positioned or have a step ahead for the FDA approval. I don't know, but that's certainly something that's been significant to watch. I'm not going to spend a lot of time on this. There have been a lot of federal bills introduced over the past couple of years to deschedule marijuana from the Controlled Substances Act. None of them really seem to get much momentum. Representative Mace's States Reform Act was just refiled in October of this year. But again, it's just kind of sits there just like all these other ones. One that gets the most headlines is the Safer Banking Act. It's passed the House 7 times. I don't know if it's 8. At least the last time I gave this presentation, or a presentation on this, it was 7 times, and it always stalls in the Senate. What's different this time is it's coming out of the Senate, but it's yet to be seen what's going to happen. And with an election coming up, these things tend to stall out. Let's see, I referenced the Dormant Commerce Clause earlier, and I've got several slides on this, but I think the biggest takeaway, so what the Dormant Commerce Clause is basically a constitutional doctrine that prevents states from treating in-state business interests differently than out-of-state business interests. Having laws that favor in-state businesses, to the detriment of an out-of-state business. And I'm sure you're all thinking like a residency requirement. One of the leading Supreme Court cases on this is this Tennessee Wine and Spirits case, where the court struck down a Tennessee residency requirement for liquor licenses. And courts across the country have applied this federal constitutional doctrine, most courts have, to tell states you can't restrict cannabis licensure to in-state businesses, or at least the way you're doing it violates the dormant commerce clause. They're not outright banning it completely, but the in-state residents. Yeah. So I guess the biggest court to do it was the First Circuit that said Maine's residency requirement violated the dormant commerce clause. So again, this is just a federal court applying a federal constitutional doctrine to basically open up a cannabis program more than it was intended to be open, which was technically illegal under federal law. Again, going back to Clarence Thomas's statement in Standing Akimbo, it's just another example of the inconsistent approach by the federal government. So, if Congress isn't going to act, and I don't know how long it may take DEA, and what that would look like from a regulatory agency perspective, what about the Supreme Court? You know, we've had a decision back in 2005 where they struck down a challenge to the CSA applying to interstate commerce, but it's been 18 years since that decision. There's been a lot of legal arguments advanced about how things have changed since then and what constitutional amendments the CSA violates. There's a recent case filed. So could it be the Supreme Court of the United States that legalizes marijuana? I think a lot of signs point to that eventually being the case. Certainly before any of these other actors do it.
Well, there's a case potentially on its way there, and it just got filed, right?
Right. Let me skip to that because this is kind of going back over Clarence Thomas's. Yeah. October 26th, Canna Provisions and Verano Holdings, which is two very large multi-state operators, sued the Attorney General in a Massachusetts federal court challenging the constitutionality of the Controlled Substances Act as it applies to intrastate, note I said intrastate, state legal marijuana programs. And they filed it in the same circuit, as I mentioned earlier, that upheld the Dormant Commerce Clause argument. So I'm sure they did that very, very purposely. So this is the type of case. In addition to some of these Dormant Commerce Clause cases, there's just all these cases out there. There's Second Amendment cases. I'm sure some of you have seen. Fifth Circuit recently said that the federal law that would penalize a marijuana user of having a firearm, at least applied to that person, was unconstitutional. You've got a similar case in the 11th Circuit, which is Alabama, Georgia, and Florida, challenging that same federal law on firearms. So that all these federal cases that are out there, and when you have circuit splits, with one circuit, like the First Circuit, decides on the Dormant Commerce Clause, and you may have a different circuit go the other way, that's when something goes to the U.S. Supreme Court. And then, of course, this lawsuit, depending on what happens, it'll ultimately get appealed up to the First Circuit, presumably, and then maybe the U.S. Supreme Court. Now, that takes time, too, but
yeah, the main point, the bottom line, as Slate said, is that there's a storm brewing at the district court and circuit court level right now on lots of different issues involving the federal touch on cannabis law. And so what we expect will happen at some point is that once those are resolved at the district court level and then appealed to the circuit court level, then the circuit splits develop or the conflict develops, and then something goes to the Supreme Court, gives the court an opportunity to address all or most of these issues. So like that takes time, but the groundwork has been laid and a lot of the circuit court actions are underway.
Well, we've been talking a lot, and I know we thrown a lot at you. There's just so much going on to mention. We'd be remiss not to mention a lot of these things, but we're certainly open up the floor to questions if there are any.
had a question about the 280E rules. So is there any discussion or expectation if slash when those rules are removed, is there any discussion around if that will be a retroactive thing, or will that just be moving forward?
That's a very good point. I went to the Benzinga conference in Chicago this past, was it September, I believe. And there was actually a fair amount of discussion about that. There's some that believe that it could be, there's an argument to be made that it is retroactive. I think you could be looking at two particular beneficiaries of that. It could be, number one, people who have, outstanding tax bills to the government based on the 280E penalties. Could they then have those wiped away? But then there's some thought that companies who have paid in taxes based on 280E could potentially get them back. So yes, there are legal arguments to be made that that's possible. And of course, seeing what the language looks like will help tell the story, but that's on the table, I think.
Yeah, that's good to hear that that's potentially going to be retroactive. And I guess my other question was, I know you mentioned if it goes to Schedule 3 status, again, those 280E rules won't apply, so they'll get to take the full deduction. And then I guess if it's not FDA approved, it's still federally illegal despite that Schedule 3 status. But the FDA approval shouldn't impact those 280E rules. Is that correct? If it's still Schedule 3, if it's not FDA approved, those deductions can still qualify.
That's my understanding of how that will play out. Yes.
It's just the Schedule 3 status that will.
That's right.
Okay, affect that rule.
I think by its language, 280E is limited to Schedule 1 and 2.
Okay.
Yeah, I mean that's a question I would want to run by one of my partners in the tax practice group. But that's
with the caveat that I was a music major and I'm not a tax lawyer. That's the answer to your question.
And I hope this didn't sound too at all doom and gloom. I know it may have come across that way. I just wanted to present all this. As Jason said, this could, and I think the likely scenario is it really doesn't change state programs really that much. I mean, of course, the 280E thing is a big piece of it, but I just struggle to see that they're going to reschedule this as a Schedule 3 drug and upend this industry that's been flourishing, I mean, across the country. And there's so many participants, so many jobs, so many patients that they're going to just upend that, restrict it, and penalize people that they haven't been penalizing before pursuant to federal policy. So it's just going to be fascinating to see it play out, because again, there's no roadmap here really to follow. I mean, you can't look at foods, you can't look, because it's being treated at least as a controlled substance if it's rescheduled. So looking at alcohol is not a direct comparison. Looking at, as I said, ketamine is not a direct comparison because there weren't state legal ketamine programs in existence. So I think ultimately it will be a good move for everyone. Although I know a lot would prefer to see descheduling versus rescheduling. It's just that the momentum for the former is not there as it is for the latter.
Well, if nobody has any other questions for Slates and Jason, I just want to say thank you both for joining us and for that presentation. It was very informative. There's a lot to unpack. I will definitely try and get a recording of this webinar onto our YouTube channel by the end of the week in case you missed any of it or you want to share it with any of your team members. But yeah, I want to appreciate or thank you guys for joining us. We will be continuing to do webinars like this in 2024. So stay tuned. Keep watch on our newsletter and our social medias. And without further ado, I appreciate it.
Thanks, Henry.
Thanks, Slates.
Thanks,
Thanks,
folks.
Jason.
Absolutely.